The United States Supreme Court is known to save the announcement of its most controversial case for the last day of each term. It's no wonder that Prince v. United States was announced just as the justices were headed out the door to close the 1997 term. The case raises deeply divisive issues involving gun control and the balance of power between the states and the federal government. Enacted by Congress in 1993, the Brady Handgun Violence Prevention Act was a federal gun control statute that established a nationwide handgun background check system. While gearing up to implement the nationwide system, interim provisions of the Brady Act temporarily required state and local officials, rather than federal officials, to conduct the background checks of prospective firearm purchasers. Under these interim provisions, firearm sellers were required to report pending firearm sales to county police chiefs, who were then required to conduct the background check and validate the sale. County sheriffs Joe Prince and Richard Mack brought separate lawsuits, arguing that the Brady Act unconstitutionally compelled state officers to enforce a federal statute. Both district courts agreed and struck down the provision as unconstitutional. The Court of Appeals for the Ninth Circuit consolidated the cases and reversed, holding that the interim provision was constitutional. The United States Supreme Court granted cert. The issue before the court was whether Congress can compel state officials to participate in the implementation of a federal program. The court held that under the 10th Amendment's anti-commandeering principle, Congress may not compel state officials to administer a federal regulatory program. Justice Scalia, writing for the 5-4 court, explained that there was no historical evidence that Congress ever had the power to compel state executives into federal service. Early congressional enactments showed that the Constitution allowed the imposition of federal standards only on state judges, who apply those standards in deciding cases, but not on officers of the state's executive branch. Next, Scalia considered how the Brady Act conflicted with constitutional structure. First, the 10th Amendment sets up a system of dual sovereignty, under which the states retain a significant amount of autonomy. Scalia noted that the act upset the careful balance of power between the federal government and the states. Federal power would increase dramatically, Scalia reasoned, if it could enlist into service the police officers of the 50 states. Additionally, the court held that the Brady Act violated the constitutional separation of powers principle because the power to execute the laws is provided to the president and federal executive branch officials only. Congress can't delegate federal executive power to state law enforcement officers, as it attempted to do here. Lastly, the court cited New York v. United States, which had determined that Congress can't force state legislatures to enact laws according to federal instructions. Scalia concluded that because Congress can't mandate state legislatures to act, it can't mandate state executive officers to act either. As a result, the court held that the Brady Act's employment of state officers to conduct background searches was unconstitutional. The court reversed the Court of Appeals. Justice O'Connor filed a concurring opinion to note that state officials could still voluntarily comply with the Brady Act despite the court's decision. Justice Thomas wrote a concurring opinion agreeing with the court's analysis, but further arguing that under the current state of the Commerce Clause doctrine, Congress didn't have the authority to regulate the in-state transfer of firearms. Justice Stevens dissented. He argued that Congress had the authority to enact the Brady Act under the Commerce Clause. Congress may also impose enforcement obligations on state officials under the Necessary and Proper Clause. Stevens reasoned that the framers envisioned a system in which the federal government may act for the benefit of the nation as a whole, and this sometimes requires the power to make demands on state officials. In another dissenting opinion, Justice Souter examined the text of a Federalist paper, the Supremacy Clause, and oaths taken by state officers to advance the argument that state officials can be enlisted into service on behalf of the national government. Finally, Justice Breyer, also dissenting, cited examples from foreign nations to demonstrate that successful systems of government employed local authorities to carry out national regulations. Prince v. United States was a monumental federalism case, memorable for its narrow interpretation of federal power and its staunch protection of state autonomy from federal incursion.